So our goal is to basically support and offer professional development events for international students in the New York City area, but we also in the future are hoping to expand outside of New York City. So, everyone is welcome, even if you're not in New York City. We also try to build sort of a very strong support system and build a strong network for all international STEM scientists. And hopefully, and as you know, for any job, a strong network is very important, whether you go to academia or industry. So we try to provide career development events, networking and social events in the city, usually like social gatherings in the Central Park. We went on a hike and so on. We also share a lot of research opportunities inside the US and as well as outside of the US. And we provide sessions like today, an immigration webinar for you guys to learn more about, for example, immigration, as it's super relevant for all of us, I think. So INET surrounds many different research institutes and universities in New York City, which I guess you can recognize around here. But again, we're trying to expand outside of the city. So currently over 900 members on our email list. So, if you're new, if it's your first time here, please shoot us an email. I put up our website, our Twitter, and all other social medias in the chat. So you can subscribe to our newsletter and get the newest newsletters in your mail. We also are looking for new members, and we have several different positions open at INET, like website manager, admin manager. We're always looking for institutional reps. These types of positions look really good on your CV. So, if you're interested in gaining more soft skills, networking, building a community at INET, please shoot us an email and apply. We're always welcome everyone. And yeah, a huge thank you to our current president, Aisha Gul, for holding this association together, and our sponsors, all the universities, as well as Frank and Delaney Immigration Law that always supports us every year and helps us put this immigration webinar. And without any further ado, I would like to pass on the presentation to Brendan.
Well, thank you. So thanks for having me again this year, and delighted to be here. And thanks for the introduction. And thank you everybody for being here and taking the time. So I will just sort of go ahead and tell you a little bit about us, and then I'll get started just very quickly. We are based in the Washington, D.C., Maryland area, very close to the National Institutes of Health. And probably I think the majority of the work that we do in our office is indeed for foreign national scientists and researchers. So we're very familiar with the issues and the situations that you guys face. I've had the good opportunity to liaise a lot with the National Postdoctoral Association over the years, and I currently serve on their advisory council. So there's a lot of issues that sort of postdocs and early to mid-career researchers face in the United States. So without further ado, I'll go ahead and get started. Just quickly, I am an attorney, but no, this is not legal advice today. It's just important to sort of remember that. This is for informational and educational purposes. So don't take it as legal advice when particular situations and particular circumstances, has to be dealt with slightly separately. And just with that in mind, when we do get to the Q&A section, if a question is a little bit too specific or personal, I will sort of respectfully defer. You will have our contact details here, so in the event that you want to reach out, please do so. Now, if I have to start and say a couple of takeaways from this session, I think this is what they'll be. So I think you got to be flexible. This is going to be a journey. It's going to be a journey that is in front of you, and there's going to be different options, and there's going to be different decisions that you're going to have to make as you sort of navigate these different circumstances that are in front of you. So be ready to be flexible as you make these decisions and looking at the opportunities that are in front of you. And also, I think, recognize that you're going to have short, medium, and long-term goals. As a foreign national working and residing in the United States on a temporary visa, you're here in a sort of short-term basis, and then you make decisions that may go into the medium and ultimately the long term as you sort of take these decisions, looking at the different visa options, etc. So I think those are two things to keep in mind in terms of some of the information that I will communicate to you over the next sort of 45 to 60 minutes. So for international postdocs who are here in the US, foreign national postdocs in the United States, without getting into the sort of specific numbers, out of the postdoctoral community across the US, more than 50% are foreign nationals. So in terms of your broader professional community, there's a significant amount of individuals who are here as postdocs, but who are foreign nationals who have to navigate these issues. Now, some of you guys may have been here for your undergrad, for graduate education, your PhD, now your postdoc, now you may be sort of early mid-career researchers. But I think it's fair to say that, in your postdoc and as you sort of move further down, or further into your career, you're now further down your career path than people who are here for undergraduate and graduate education. So therefore, you're facing different issues. The situations that you face are a little different, the circumstances that you have to deal with. And so therefore, the decision-making process can become a little different than it was earlier in your life and earlier in your career. So in terms of the outset, it's important to note that this is a road that you will follow, that are, you don't have to run before you can walk. And there are options in front of you. So broadly speaking, when we look at the temporary options that are in front of you, you've got your F1, your OPT, your optional practical training, and then the STEM extension, which is good for up to 3 years. And then a very commonly utilized visa, certainly in academia, is the J1 Research Scholar visa, which is good for up to 5. And then we have the H1B, which is good for up to 6. So conservatively, you've got up to 14 years of temporary visa status that is in front of you that you can utilize and harness after your PhD. Now, obviously, not everyone will utilize all of this time, but I think it is important to note that that is options for you, that these are different non-immigrant visas that you can use and harness. And there will be one or two other options that we'll go through as we talk today, but these are the most common sort of pathway, certainly in academia.
Brendan, sorry, are you sharing your slides?
Yeah.
No, we're not seeing them.
You're not seeing them?
Can you share again?
Yeah, sorry. Apologies.
My bad.
Is that it now?
Yes, looks great.
Sorry, apologies. Okay, now I'm going to run through these really quickly. I thought they were sharing. There's the legal disclaimer again that I talked about earlier. Again, this is not legal advice. This is for information and educational purposes. And therefore, we talked about that a little earlier. And there's what we talked about in terms of our takeaways, being flexible. We got to recognize we have short, medium, and long-term goals. And this is where we were in terms of the different issues and visa options that are on the table. And now we'll go current. We'll bring things right current again. And in academia, who can help you? Because you've got the different visa situations, visa questions, visa issues that you're facing. So who can help? If you're in academia, one of the things to remember and understand is that you're still under the umbrella of the international office. And I can't stress this enough, that this is something to remember to understand, that if you are in OPT, your STEM OPT, or here as a J1 research scholar, here as a H1B, and you're in an academic setting, talk to your international office. Regardless of your institution or your university or the organization, they will be there to provide assistance and context to your questions. A couple of things about that. Everyone has friends, colleagues, but a lot of times they're at different institutions, different organizations. So it's important to know what is actual in your institution, okay? Because titles and positions matter, and they can be different at different institutions. Information is good, but make sure you get the correct information at and from your institution. So the international office is very important to stay in touch. The career office as well. There's going to be a lot of different sort of issues that are going to come together as you make this journey and as you answer these questions for yourself. And so bring the career office into check to make sure that you're making decisions about different career opportunities. And the postdoc office and or networking organizations. And Gabrielle mentioned at the outset about INET doing a lot of these different events, a lot of these different networking events. And one thing, I mean, yes, I come and I do the immigration and the visa one, but I've had the opportunity over time to go to many conferences, the National Postdoctoral Association conference, and I see all of the different resources that you guys get. And I think it's really important not to just sort of check in and be like, oh, I've got questions about my visa. Let me see what's going on with the immigration and visa one. But go to all the other events that INET are putting on for you, because at the end of the day, this is going to be a sort of package deal. You will get information and positive resources that you can potentially utilize in an immigration or visa application. So I really urge people to do that all the time. Take all of the resources that you have, because networking organizations, postdoc offices, and the like, being proactive just like today, provides definite enhancement for you as an individual. There's no question about that. And what does being proactive mean? Well, the idea of organizing seminars and programs, again, just like today, but it also allows you to keep abreast of changes or potential issues that are coming up in a given area or a given field. So companies, organizations, INET, it can all help you get to where you want to be. I'll go back again about in an academic sense. Don't be afraid to reach out to and interact with your international office, okay? They will be there to assist you with certain issues, certain concerns. There will also be postdoc offices, postdoc associations. So in an academic sense, there's going to be a lot of potential organizations or forums or resources that can provide you with assistance. So basic knowledge, okay? This is what I'm going to try to impart to you today. And it's really important to stay informed. We were speaking a little bit just before this commenced, and there are always changes in immigration law. There's always sort of changes on the landscape. And it's important, not necessarily to know every minutia, but it's important, I think, to stay informed about the issues that are impacting you as an individual, you professionally and personally, as you make these steps in terms of your immigration and career journey. So with that being said, what's been happening? What's been happening broadly in the immigration sort of universe? Well, I'll start with some of the bad news, or the frustrating news, let's say. There's delayed and inconsistent timelines. You know, I think broadly speaking, we sort of hope for and we strive for consistency in many sort of aspects of our lives. And certainly when you're dealing with the government, you would hope they would be consistent. Unfortunately, that's not necessarily the case. So we do see a lot of delays and inconsistencies in terms of the timelines for adjudication. That can be frustrating because let's say, for example, you file an application for a green card and you may have a friend or a colleague who files their application and they get approved after 4 months and you're waiting for 8 months or 9 months or 10 months and you say, well, what's wrong with my case? It's a sort of, it's not you, it's them. It's not necessarily a problem with your case. It's a problem with how immigration adjudicate and the timelines for adjudication. So it can get frustrating. However, with that being said, I do have to give them credit that last fiscal year, so about a year, 14 months ago, around August and September of 2022, they really raced through adjudication of green card applications to try and get as many and clear up a sort of backlog of pending cases. And to be fair, they actually cleared out a lot of pending cases. So they were able to issue a lot of green cards last fiscal year that cleared up a lot of their backlog. And that was good. It had ramifications, slight ramifications down the line that we're now experiencing. And I'll speak to that in a moment. If you are pursuing a green card on an employment-based standard, your final I-485 adjustment of status is now almost certainly being transferred to the National Benefits Centre, which is now allowing for your final green card to be processed and issued by a local office without the need for you to turn up for an interview. So again, that's a positive step forward. Okay, the fact that USCIS can now take an final employment-based green card application and look at the evidence, look at the documentation, and not need to call the applicant in for a final interview is pretty solid. But let's revert. Another frustrating part, the lack of combo cards that are being issued. And what does that mean? What it means is that when one files for a green card, part of the application process entails filing temporary work and temporary travel authorization. And for the last number of years, those have been issued as what we call a combination card, a combo card. They issue the work and travel. It looks like a little driver's license. Look, they issue it as a combo card. It says work authorization and eligible for travel, I-512 advanced parole. For some reason, immigration have sort of bifurcated those approvals out, even though they're both filed together, generally speaking. They have taken to issuing only the employment and are holding back on the travel. And that leads to my next point, collateral damage for applicants. So it may be that you qualify for a green card, your I-140 may have been approved, you filed to adjust your status, and yet for some reason, immigration may have only issued you a temporary work permit, but have not yet issued you your travel permit. It's good that you can continue to go to work, but we also want to lead our lives. And as foreign nationals residing in the United States, part of that is the ability and opportunity to potentially travel outside the United States, to potentially travel home. So some of the collateral damage for applicants is just that. So we have to also try and navigate that and be prepared for that as we take the steps in this process. As we move forward from here, so over the last number of months, it's clear we have seen more significant number of applications being filed under employment-based cases, which has led to more significant visa retrogression over the past year. And therefore, we're going to have more uncertainty about timelines for final adjudication and processing of green cards moving forward from here. So that's a sort of, a synopsis of some of the main points that's been happening on the ground, so to speak. But what's this? This is new. It shouldn't say what's new. It should say what's new-ish, because it's been around for a little while. But this is important because for years, people have been sort of saying, well, STEM is recognized for its importance to immigration, to the economy, all of that good stuff. Why are they not giving us enough sort of additional weight? Well, now there is. In January of 2022, guidance was published in terms of national interest waiver applications and O1s. And just recently, additional guidance has recently been published to also incorporate EB1A, extraordinary ability applications, and EB1B, outstanding professor or researchers. What does this all mean? Well, it means that we now have more deference to STEM-related applications of individuals filing for green cards. I want to be clear, it hasn't changed the standard. It doesn't make the standard suddenly easier. What I think it does do, however, is potentially allow for a less restrictive reading of the evidence to be applied by officers. But we're going to have to wait, certainly in an EB1A context, because the guidance has been very recent. We're going to have to wait to see how individual officers are actually applying this to their adjudication of cases. But it's clear that it's a step in the right direction. It's clear that there is more recognition at USCIS of STEM-related applicants filing for green cards, and that they can now give more weight to the types of evidence and documentation and material that those involved in STEM-related applications, scientific research, etc., can bring to the table. So what does this do for you individually, and what sort of questions are you going to ask? Because this is not just about sort of, oh, here's my visa, I'm going to do this. Where does this take you in your career pathway? What options do you have? You're going to face issues, but where does this all take you individually, personally, and professionally? Well, generally speaking, we're sort of looking at the idea of, do you remain in academia or do you want to go to industry? And each pathway can sort of present different concerns, circumstances, issues, and also in certain instances, roadblocks. So the academia versus industry question becomes, for many people, front and center. If that's the case, which visa do you use? Do you do a J1, H1B, an OPT? If you're in academia, A J1 research scholar visa that we'll talk a little bit in a moment is very common. Can you transfer it? Can you transfer a H1B? What can you do with the different visas that you hold? Can I do an O1A if I want to go to industry? And ultimately, as I mentioned at the outset, for foreign nationals residing in the United States, the final question really becomes, do I want to be here temporarily or do I want to be here on a permanent basis? And a lot of the steps that you will take, a lot of the decisions that you will make will be ultimately based upon that final step. So I'm going to go through some of the most commonly sort of used visas that I talked about a little bit at the outset. Very briefly, because I could do a whole presentation on F1 OPT and STEM extension. It is very heavily regulated. There's a lot of information out there, but just very quickly, if you're on OPT or the STEM extension, make sure and talk to your international office. They are your friend. I think you have to be very careful in not doing things, not engaging in certain activities while on STEM, while on OPT or the STEM extension that may in fact be unauthorized. Okay, so there's a lot of regulations regarding OPT and the STEM extension. Post-completion OPT is good for 12 months, and then you have the STEM extension, which is good for an additional 24 months. For the STEM extension, you must have a qualifying STEM degree. They have expanded the number of degrees and professional areas that actually qualify under this extension, but you got to make sure that your degree does in fact qualify for the STEM extension. If you are pursuing this, your employer must be an E-Verify employer for STEM extension activities, and there must be a bona fide employer-employee relationship. So the idea under the STEM extension of volunteer or self-employment work is generally not permitted. So the STEM extension actually carries slightly less flexibility than the post-completion OPT. And that's why I say, make sure and speak to the international office, make sure and get guidance if you have any sort of possible concerns, because the last thing you want to do is sort of engage in some type of activities that would not be authorized by your status. If you use your post-completion OPT and or the STEM extension to leave academia, just be careful about the next steps and what your visa options are going to be after that. For example, the H1B. The reason I say that is that if you utilize or harness the OPT, post-completion OPT, and or the STEM extension to go to industry, for example, that will run out at a certain time. And for most people, they will, if they're in an industry situation, then they'll have to enter the H1B lottery. And the numbers that we're seeing in the H1B lottery over the last couple of years are extensive. And so it is potentially not necessarily closing doors, but it can have repercussions if you use that to jump to industry. So there are potentially, as you may be aware, and as we'll probably talk about, tend to be slightly less visa options in an industry situation rather than academia. But let's say you harness your post-completion OPT, your STEM extension, what would the next option be? Certainly in an academic situation, the J1 visa research scholar, which is good for up to 5 years, is a very heavily utilized visa. And there's a lot of pluses to this. You generally don't have to deal with USCIS, and I have to deal with USCIS every day. So anytime you don't have to deal with them, it's probably not a bad thing. And within an academic setting, the J1 visa is actually fairly easy to administer and is pretty easy and not restrictive to transfer. Each university will have a DSO. They can transfer your DS 2019 fairly easily if you want to move research labs and things like that. If you're married, your J2 spouse can apply for employment authorization. And there are also some tax treaties, which I'm not necessarily going to get into, but for some people, there can be a slight benefit there, certainly at the outset. But it's not all roses, because under the J1, we also have 212E. And 212E is a 2-year home residence. The J visa is in effect an exchange visitor program. It's been around since, I think, just about after World War II. It comes in many different forms. It comes in many different subcategories. But in many instances, the idea behind it is that people in different categories would come to the United States for either, training, internships, exchange visitor programs, and at the end of their J visa time would go back to their home country. And for J1 research scholar visas, for many instances, that may be still required. If you are subject to 212E, it will generally speaking be either that you are on your home country's skills list, and not every country has a skills list, and not every occupation is on the skills list, so you got to make sure and check, and or you receive government or funding or international organization funding. If you are therefore subject, you need to either get a waiver of your 2-year home residence requirement or fulfill it. It doesn't go away. And you need to get that waiver if you want to get a H-1B or a green card. So if you are subject to 212E, it is something that you have to recognize and take care of. There's no question. You cannot change status if 212E applies. Now, it is not completely uncommon for someone to have a discrepancy in their paperwork. And what does that mean? The DS 2019 may be issued by the university and it may say not subject, but the visa stamp gets issued by the consulate and it says subject. So which is it? Well, that can be difficult to ascertain because at the end of the day, it's not necessarily the consulate officer the stamp that will control. So if there's any discrepancy in whether you feel that you are subject or not, you can get what's called an advisory opinion from the US State Department, the Visa Office, the Waiver Review Division, who will give you a binding opinion if you're subject or not. At the end of the day, if you're subject, you got to take care of it. And so that's an important aspect. The J1 Research Scholar Visa is much more commonly utilized in an academic setting. There have been, over the past number of years, more programs in an industry setting that can now allow people to use the J visa in an industry capacity. But for the most part, it's most commonly utilized in an academic setting. So again, a lot of positives for it, some negatives under 212E, and it's just something if 212E is in your life, you need to address it. And then we have the H-1B. So the big thing about the H-1B, certainly between academia and industry, is the idea of, is it cap subject or cap exempt? That's the biggest question that people tend to face. And essentially what that means is that in academia, the academic institutions, universities, and nonprofit research organizations, there's a few other examples, but those are the big ones, are exempt from the cap. So if you're in an academic setting, a H-1B can be filed on your behalf at any time. There is always availability. That is not the case in industry. In an industry setting, and I use that term very broadly, essentially for-profit industry over all professions, there's 85,000 H-1Bs that are given out each year. And the cap gets reached at the start of each fiscal year. I mean, I think it was close to 500,000 or something ridiculous files last year. So the chances of getting accepted in the lottery tends to dwindle each year because the amount of cases that are being filed just continues on an upward trajectory each year. So the chances of getting accepted in the H-1B lottery tends to diminish. However, a couple of main differences for the H-1B versus the other two visas that I spoke about is that the H-1B is dual intent. So if you're pursuing a green card application, the H-1B can be maintained up until the day you get your green card. You can continue to work and travel on your H-1B after filing and while pursuing a green card. That's very different from the J1 and the F1, which are strictly non-immigrant temporary visas. But also, I sort of touched on this earlier, know the policy where you are because titles and positions matter. University A versus University B may actually have different policies and procedures as to whom they may sponsor for a H-1B visa. So while you may be eligible to be approved for a H-1B visa, you also need to make sure that the policies and procedures are in place at your organization or your institution, that they will in fact sponsor you for the position that you hold. And that goes back to sort of speaking to the international office, having conversations, making sure that you are aware and appraised of what sort of goes on within your institution. Under the previous administration, under the Trump administration, there was a lot of pushback on the H-1B visa adjudication process. We definitely saw a lot of sort of higher levels of scrutiny and standards of adjudication. There was a lot of pushback on wages, prevailing wages, types of positions, certainly in computer-oriented occupations, computer programming, software engineering, and similar. I think it's fair to say that is less of a problem now. It's still a slight issue, but I think for the most part, broadly speaking, if you're engaged in scientific research with the type of qualifications that the folks here in the audience have, then a H-1B should be approved on your behalf. But these are still just some issues to be cognizant of. So what about the O1? The O1 is an interesting sort of visa. Some people refer to it as the Einstein visa. I don't think we have to go that far, but it's definitely akin to the EB-1A extraordinary ability visa that we'll talk about in a moment. And it's a very restrictive standard. Now, keep in mind, I did mention earlier that the STEM guidance from last year did indicate that STEM applicants should be given more deference and weight to the evidence under O1 visa applications for them. So that opens the door a little bit for potentially more people to conceivably qualify under the O1 than prior to that guidance being published, which is, as it says there, that's a good option for industry. Because two things to keep in mind about the O1 is that, first of all, as it says there, if you're subject to the 2-year home residence requirement, you do not need a waiver to get an O1. Now, you need the employer to sponsor the O1. It would have to be approved. You would leave to get the visa and return. This is if you're subject to 212E. And you would then be here as an O1 non-immigrant. You would still have to take care of 212E. But again, if you have a 2-year home residence requirement, the O1 visa is an option because the H-1B is not. It's also a good option, an excellent option really for industry, because given that these H-1Bs are just being gobbled up each year in April, there's very limited window to be able to obtain a H-1B in an industry capacity, but the O1s are always available. There's not really a discernible time limit on O1s, so you can sort of hang out here for a while using your O1 if other options don't arise. But as I said, it is a restrictive standard. Let's not kid ourselves. Let's not think that, okay, I do this type of research, therefore I'll file this case and I'll get approved. No, you still have to meet the standard, and the standard for O1 is extraordinary ability. And just quickly, that sometimes I think people have a little bit of a misconception about, oh, can I file an O1 for myself? The answer is no. The O1 requires an employer-employee relationship. There has to be a sponsoring employer to file the O1 on your behalf. So you just need to be clear about that in looking at it as an option. So having looked at some of the more sort of commonly utilized and held sort of temporary visas, you're now sort of saying, okay, I'm maybe using the J1. I've taken care of my F. I've used the STEM extension. I'm on a H-1B. I'm trying to sort of get an O visa. How do I navigate all this? Because I'm trying to sort of, on one hand, jump around between different visas that are in play. I'm trying to sort of align that with my career choices, my career developments. How does this all sort of work? How does this all play together? And the question sometimes is, do you feel constrained with regards to your visa situation? Is this bringing sort of added pressure to your situation? And so think about the alternatives. Look at what options may be in front of you that will enable you to positively navigate this journey, okay? There will almost certainly be alternatives. Sometimes they may not be the best alternatives. And that's why I said at the outset that it is important to be flexible as we navigate some of these choices. But don't be afraid to look at the different options and alternatives that might be in front of you. It might not be perfect for the immediacy, but it might be a stepping stone to where you need to go to. As you're employed, do you know your employer's policies? Because sometimes the question is, in an industry capacity or in academia, is institutional or company sponsorship a possibility? Now, personally, I'm not the biggest fan of sort of, getting your H-1B on day one on October 2nd, on day two, knocking on somebody's door and saying, oh, do you guys sponsor me a green card? Any chance of a green card? Probably not the best sort of course of action to take in terms of your introduction to the employer or whatever. But with that being said, you also don't want to wait till year 5 to find out that they do not sponsor green cards. So find out in an appropriate method, manner, timeline, what the options are for you on a sort of medium to long-term basis in terms of immigration help with a company, with an institution, with an organization, because I think that's a valid sort of step or place to be. And I do want to say one thing here that I think is very important. Even though this can be frustrating, you have to remember that as highly qualified individuals who are working in a professional arena that is recognized for its importance, that you guys have options that many other qualified professionals do not. The United States has, I don't even know, pick a number, hundreds of thousands, millions of qualified professionals in different professional arenas working in this country. But not everyone can self-petition. And so therefore, there are options for scientists and researchers that are not available to other well-qualified professionals. So let me ask the question, are you aware of self-sponsored green cards? Do you know how you can make this process work for you? And also, the idea of having multiple career options outside of academia, I think it's fair to say, and I mentioned at the outset that I've had a lot of good times working with and aligning and liaising, I suppose, with the NPA, National Postdoctoral Association. And I remember a number of years ago that the idea of, like, it would sort of call it non-traditional careers. I think that ship has sailed. They're just career paths now. So there are multiple career paths and career options outside of academia that you can continue to pursue under self-sponsored green card options. So what is this? How do we look at potentially on a longer term basis pursuing a green card? Well, you have, broadly speaking, employer sponsored versus self-sponsored. The employer sponsored green card process is what I would term the traditional method and is somewhat easily navigable. You've heard about people being sponsored for a green card by their employer. However, in a self-petitioned universe, you are the one driving the process. And therefore, generally speaking, it can give you additional options and it can enable you and allow you to open doors for yourself. That being tied to an employer in an employer-sponsored application may not. With that said, we need to remember that it is a restrictive standard. Be prepared and understand the process. One thing I like to say a lot when I'm talking to sort of potential clients, when they come to me with their CV and they say, hey, Brendan, what do you think about my case? How strong does my potential case look? I look at it and I give them my feedback. But one of the things that I tell people that everyone has to remember is that all of the research is important. Not all of the research is significant. And it's the substance of your accomplishments and your contributions that will give you the ability to meet these standards that we'll talk about in a few minutes. So under a self-petitioned application, what about the idea of transitional and non-traditional fields? Are they allowed? Can you pursue non-traditional, transitional fields? The answer is yes, but we just got to be careful about continuing to show the application of our scientific knowledge. Is it the same or allied field? But ultimately, if you can process a self-petitioned application, almost certainly you will have more options moving forward regarding ongoing employment. For employer-sponsored green cards, this is just a pretty informational sort of checklist here. We have 3 basic ways to do it. You have PERM, which is the traditional method, generally in an industry situation, industry capacity. We have special handling, which is in a university setting, so it's slightly different administrative process. We also have the outstanding researcher, which is an EB1, which can be attractive for a lot of people, given the lack of backlogs or the lesser backlog under EB1. This is where there are a number of criteria that are listed, and you have to meet at least 2-3 years experience. Important to note, all of these processes are employer sponsored. You can't do any of these yourself. However, that did not. Let me just go back. However, under self-sponsored green cards, you can. You are the one driving the bus. So if you are going to consider and/or pursue a self-petitioned green card, here are some things that you want to consider. First of all, what is it? Well, it's a self-sponsored green card. You are petitioning on your own behalf to ask for a green card. It's not an employer petitioning on your behalf. It's you. You are putting your best foot forward to say, I am requesting US permanent residence. So what are you asking in this application? Well, as I like to say, it's a very fancy way of asking a very simple question. Do I qualify for a green card? Do I qualify for a green card as an alien of extraordinary ability? Do I qualify for a green card as an advanced degree alien performing work in the US national interest? That's the question that you're asking when you file one of these applications. So the next logical sort of step to take is, well, are you qualified? And that's where I go back to what I said a moment ago. You need strong professional credentials. The importance of your work in and of itself is not enough. There's many people doing important research. So what enables you to stand out? What enables you to prepare and file a strong case? Well, I think the preparation and being ready and going and filing this type of case at the right time for you is important. This is not going to be a sort of one size fits all answer. This is not going to be the same pathway traveled by everyone in the same way. Some people will naturally sort of be able to navigate it more quickly. For some, it's going to take longer. So I think preparing yourself based upon your own professional credentials, based upon your own background and where you need to be is important. And that includes getting a full and frank evaluation of your credentials. Be careful about sort of going to the well too early. You know, as I said a moment ago, I've had the good opportunity. I liaise, I speak to people all the time. And sometimes I look at someone's CV and I say, look, you're pretty accomplished, but you're just not there yet because here's a weakness. Maybe your work, maybe you've published on a number of occasions, but the citation is too low. Maybe there's other facets that we're just not seeing. So get a full and frank evaluation of your credentials. Yes, it's nice to hear the strengths. It's nice to hear how good we are in life, professionally or whatever, but don't be afraid to get feedback in terms of, listen, you may not just be ready to file yet because, okay, so take all that on board. And if you are pursuing a self-petitioned application, it's about the intent to continue working in your field. So you got to qualify EB1A extraordinary ability, EB2 national interest waiver, but you also have to show the intent to continue working in your field. However, as I mentioned earlier, you are not tied to a specific employer, and therefore doors are now open. Another point, you do not have to be physically present in the US to file this application. You can apply from overseas, and if approved, come into the US or come back to the US with your green card. The adjudication process is based upon your professional credentials, accomplishments, contributions, etc., not based upon your physical presence in the United States. Your level of standing, your level of ability in the field for EB1A extraordinary ability will be adjudicated based upon your credentials, regardless of your physical presence in the United States or elsewhere. Research, scientific research, health-related scientific research is in the United States national interest, regardless of where the person is physically present here or elsewhere. So these are options for you moving forward in the long term, regardless of where life and career takes you. but you got to qualify. So how do we do that? So under the EB1A extraordinary ability, here's the standard. Ultimately, you have to show that you have sustained national or international acclaim and that you're one of the few at the top of your field. There are 10 listed criteria, of which you have to meet 3. Some of them don't even apply to the sciences, however. We see there in the sort of lower center, evidence that your work has been displayed at artistic exhibitions and showcases. That doesn't mean display at conferences, scientific conferences, it means artistic. Because extraordinary ability is for people in any range of fields who can show that they're at the top of their respective fields. Generally speaking, some of these are objective. So for example, if you can show that you have authorship of scholarly articles down towards the bottom right there, that's pretty objective. Once you've published in journals, you can meet that category. And if you've peer reviewed, you would generally get the judge of the work of others. But you got to meet that third category. And generally speaking, in many occasions, I think it's fair to say most occasions, it's going to come down to the extent to which you can show that your original scientific related contributions can be seen to be of major significance to the field. Do you have original scientific or scholarly contributions of major significance? And we have to break that down because yes, the contribution is original. And depending upon how it was disseminated, the manner of its recognition, etc., you may have a pretty solid, strong argument to say it was significant, but can we show that it was of major significance? And that's a little bit more subjective and discretionary. But those are the types of sort of categories that you have to meet. And then you have to show that you're recognized as one of the few at the top of your field, that you have sustained national or international acclaim, what I would term a consistent career of excellence. So as you may see, the idea of meeting the standard for EB1A is not easy. Now, we do have this new guidance that's been published. Let's see how this plays out. Let's hope that this opens doors for perhaps more people to qualify, but it is not an easy standard. And I think people have to recognize that. Almost certainly, the national interest waiver is a better alternative for sort of early and mid-career researchers. Under the NIW, we're looking more at a sort of cumulative and broad analysis of your overall body of work. Now, as I mentioned earlier, everyone's doing important research. So the mere act of sort of publication or presentation in and of itself is not going to be enough. That is inherent in your profession. You guys are supposed to publish and present and disseminate. So there's got to be more, which we'll get to in a moment. However, as in the EB1A, you're the one driving the process. You need to show continuation in your field, but you're not tied to any specific employer. The test under the NIW is this. First of all, we have to show that the proposed endeavor carries substantial merit and national importance, which again, as a scientific researcher, you really shouldn't have too many problems or issues showing that. It's really under part 2 that makes or breaks this case. Can we show that the foreign national is well positioned to advance the proposed endeavor? And when push comes to shove, that's when you have the opportunity. Remember, the burden is on us. The burden is on you to make this case. But to show that you're well positioned to advance the proposed endeavor essentially brings into play the evidence such as publications, standards of publications, the manner and extent of your contributions to your field. And once you can sort of meet that standard, then generally speaking, it will flow, part 3 will flow from that. Because of the merit and national importance of the work and the extent to which you're well positioned to advance the field, then generally speaking, yes, it will be beneficial to the United States to have you here on a permanent basis. So the EB2 national interest waiver, almost always for scientists, it's can you meet part 2? And if you can, the case is in a really good place. For researchers, I think it's fair to say for officers, immigration officers who are adjudicating research applications, that citation still continues to carry a high degree of importance, certainly in the EB1A universe. I think less so in the EB2 NIW, because it's a less restrictive standard and we can show sort of being well positioned to advance the field in different ways. But certainly look at your cover articles, your editorial highlights, your standards of publication, the rankings of the journals, all of that good stuff. Important to show not just what you have done, but the extent and manner in which others may have utilized and implemented your findings in their own research. Documentation of grants and funding of your work. This all matters. This all means something. Ultimately, the question is, are you one of the few at the top of your field? If you're looking for an EB1A under the EB2 NIW, how well positioned are you to continue to advance the proposed endeavor? And the evidence that we bring to the table is the stuff, the material, the documentation that flows from a scientific career. Get published. Some people ask, well, how many publications do I need? Difficult to answer, because the person with 4 publications in Cell, Science, Proceedings of the National Academy of Science, and the New England Journal of Medicine probably has impacted the field more than someone who has published on more occasions but in lower ranked journals. So it's all relative. Certainly peer reviewing is something that whereby you can help yourself. Involvement in grants, citation of your work by others. Caveat, not all disciplines are created equal. We've had the good opportunity to work with a number of researchers from NASA. Aerospace engineers tend not to get cited as much as people do in molecular biology basic research. So what is the strength and weight of your evidence? Think about your evidence in your case. The letters of recommendation are important. Be ready to have strong letters of recommendation that corroborate all of the other evidence in the record. Letters alone are not going to get you there. You need substance, you need specifics, you need detail to your accomplishments. But also network. Use your professional relationships, because that can harness the ability to maybe get that extra letter of recommendation. It may enable you to get an invitation to peer review. So make sure and harness those professional relationships as you continue your career progression here in the United States. And what about the idea of the transitional and non-traditional careers? Ultimately, the question is, in pursuing a self-sponsored application, you're required to show that you have the intent to continue working in the same or allied field of endeavor. So no, you are not restricted to academia. The application of scientific knowledge comes in a number of different ways in a myriad of different positions. So as long as you can show that you're in the same or allied field, applying your scientific knowledge, then you should be able to transition through positions as your career moves forward, utilizing a self-petitioned application. I'm going to make some house calls now. So we've looked at filing for the green card. Hopefully you get approved. So then you need to get your green card. Well, the final step is, if you're residing in the United States, is the adjustment of status. How am I going to adjust my status from temporary resident to permanent resident? Well, the US gives out a finite number of green cards each year, about 140,000 under employment-based processes. And it's divvied up into the different categories. So we have here EB1, and this is off of the October visa bulletin. EB1, so all countries, caveat, no one country or countries can take more than 7% from the bucket of visas. So we have China and India who have oversubscribed their available numbers over the past number of years. So everyone else is current, means you can file your adjustment of status either with or immediately after your EB1 is approved. China, you would have to have an EB1 approved, filed or approved July 1st, 2019. And for China, mainland China, it's August 1st, 2022. If you're pursuing EB2, which is going to be your NIW, or if you're getting sponsored for PERM, all countries is January 1st of 2023. Usually in October, that's current. Usually when a new fiscal year arrives, that's current. But as I said earlier, we saw more retrogression this year, so it's backlogged a little. India it's a disaster. That might say May 15th of 2012, but anyone in the audience from India knows that does not mean it's 11 years out. It really, there's little to no incremental forward movement. China is January 1st of 2020. However, especially for people from India and China, strategize, because you can hold your place in line by filing an EB2. So sometimes people throw their hands up and say, what's the point in filing an EB2 NIW? Well, the point is twofold or threefold. A, an approved EB2 allows you to extend your H1B beyond the 6-year limit. It can allow your H4 spouse to obtain work authorization, and it also establishes your priority date for any subsequently filed EB applications. So there are definite positive ramifications for getting that EB2 approved earlier if you're from India or China. But it's a process. And it's not an easy process, and it can be a frustrating process. So I think we have to be mature enough to sort of look at this and approach this pragmatically, because it can be, it can be difficult. But I do firmly believe, and I mentioned this earlier, given the nature of your professional endeavors, given the fields that you guys are in, if you prepare yourselves and learn what is in front of you, you can get to where you need to be. I know it can be frustrating at times, but at the end of the day, science and research is recognized for its importance in this country. And I know it may not feel like this all the time, but so are international researchers. And I know that there are organizations that over the years have done a lot of advocacy for international researchers, and that continues to move in a positive manner. So with the proper guidance, you can get to where you want and need to be. I do believe that. I'm going to finish with just some very brief housekeeping. If you got to go and get a visa stamp, make the appointment well in advance. There is a pilot program that can potentially see visas renewed and issued here in the US. Let's see where that goes. If I'm not here you shouldn't be drinking and driving. If you get a DUI or a DWI, you could get your visa revoked. You do not even need a conviction. We are in an era of extreme vetting. Social media, phones, and computers are in play for CBP to look at the border. However, on a more positive note, USCIS have indicated they've now returned to giving deference to prior approvals. What that essentially means is, let's say you hold an O1 visa and you want to extend it. Under the previous administration, each application was looked at new. This administration has gone back to deference, which means that if you were previously approved for the same or similar position, they will essentially move and approve the next one. And finally, yes, I live in DC, and I don't know what they do down in that big building down the road from me. Not a lot when it comes to immigration. I can certainly tell you that. So it's been a rough year. It's been a rough few years, certainly in terms of the politics of all of this. As I mentioned earlier in this conversation, it's been a rough year for case processing and administration of cases, and it's frustrating. It's frustrating for me professionally. It's frustrating for you guys who try to navigate this. I will say, however, that I'm seeing in real time the adjudication of EB2 NIW cases have definitely speeded up. There are some that just unfortunately get lost in the shuffle a little bit, but I think broadly speaking, that's more positive. Will Congress pass a bill? I mean, they thought something called budget reconciliation was maybe going to be the answer. I mean, they don't even have a speaker right now, so they can't do anything. But I don't think it's likely. We're now into another election cycle. This is my personal opinion that immigration is a very hot topic. It's a hot potato, and I would be surprised to see it gaining any traction over the next year. I would love to be proven wrong, but that would be how I would see things. But as I mentioned earlier, STEM is now in play. STEM is in play in a positive manner via executive order, and that's a big step forward. So, let's see how the guidance continues to be applied by sort of individual officers. And if they can continue to apply it positively, then that will continue to sort of push that door further ajar for you guys as you prepare and file these applications in a positive manner. So with that, I will finish up. I thank everybody again for the invitation to chat today. Sorry about the technical snafu at the start. It wouldn't be a virtual Zoom meeting without some type of little snafu. So, but we got there. So thanks again, and I guess we'll open it up to some Q&A.
Yeah, thank you so much, Brendan. Hopefully everyone feels a little bit better and a little bit of clarity during this process. So now we can just go into Q&A. So I'll read stuff from the chat to Brendan and he can answer as we go. So first question, can you please explain the difference between filing date and final action?
Yes, so basically the visa bulletin publishes two columns. We have filing dates and final action. And it's essentially the State Department is who publishes the visa bulletin, and they project about how many cases are in the backlog, and they therefore project about when you should be able to file an adjustment of status, etc. And it used to be only one column. So the idea of filing dates and final action only came into vogue a few years ago. I can't remember exactly when. It essentially is based upon what they predicate as what a reasonable objective would be to enable people to file the applications. So I think what they're trying to do is, on one hand, they're trying to allow more people to sort of get into the queue without overburdening the visa numbers that are there. So if you look at the visa bulletin on a monthly basis, sometimes it'll actually allow you to file your adjustment based upon a filing column or a final action. Generally speaking, final action deals with when the application is there to be finally adjudicated. But given the inconsistencies in processing times and the fact that it sort of backlogs back and forth, I don't know that there's a massive difference between them, and it's really more to do with when you're eligible to file your case, and it can change from a month-to-month basis.
Next question would be, if I understand this correctly, that even after a couple of years after you left the US, you can still apply for EB2?
Yeah, correct. So basically, and that's one of the benefits and one of the beauties of having the professional credentials and accomplishments to qualify under an EB2 or indeed an EB1A. You know, as I said in the chat, or in the webinar, this is based upon your professional credentials. So you could be here in the United States. I'm from Belfast, Ireland, Northern Ireland. It's like I could be back there. I could be sitting on the moon, and I could file this case if I have the credentials. Research is research, regardless of where you are physically located. So the answer to that question is yes. If you have to leave the United States and you continue, your professional career continues to move forward in a positive manner, and you've got the credentials and the attributes to file this type of case, you can absolutely apply from outside the US when you're at home at whatever point.
Are first authored publications the only ones that count, or do co-authorships count as well?
Yeah, so definitely co-authorships count as well. Now, listen, as you guys know, I don't think I need to sort of parse out what role is played by different authors in different sort of papers. So generally speaking, yes, co-authorships work. The one thing I would caution people about is that if you are in a sort of large collaborative study, then that can be a little bit more difficult to define or discern what your actual role and or level of contribution may be. Now, when you talk about co-authorships, are you a leading author or a less than leading author? If less than leading author, it may not carry as much weight, especially in an EB1, but certainly I don't discount them.
So with a J1 status, if this person filed I-140 petition, can they travel outside of the country?
So I'm going to tread carefully here, because I cannot get into a answer that could potentially constitute legal advice. What I will say is that keep in mind two things: that a J1 visa is a non-immigrant status and a non-immigrant visa. It does not carry the same level of dual intent as a H1B. Once you file an I-140, you have evidenced what we call immigrant intent. You've told the US government you want to be here permanently. So I would certainly caution anyone to travel outside the US and attempt re-entry on a J visa after filing an I-140.
So with will the immigration tendencies impact the extension of OA1 visa? This person's plan is applying for OA1 first and then applying for the NIW. However, it seems like the waiting time for NIW is longer than 3 years.
So if I'm reading this question correctly, I think this person is asking, so if they apply for an O1 and let's say they get their 3 years for the O1, because that can generally be applied for the 3-year period, and then they apply for the NIW, will that negatively impact the ability to extend an O1? The answer to that is no. The filing for an NIW will not in and of itself impact one's ability to continue to extend O1 status. So an O1 can be approved for 3 years at the start and then will generally be approved on a yearly basis after that. So yes, if you're essentially utilizing or harnessing the O1 to remain in valid non-immigrant status in the US, and then over here in parallel, you've sort of filed your NIW because you want to get a green card, then that's fine. And the O1 can still be extended.
Next question is the spouse of a postdoc on H-1B visa allowed to work in the US and able to apply for EID?
Only under limited circumstances. Generally speaking, if the principal applicant, the H-1B holder has an approved I-140, then the H-4 can apply for work authorization. But in and of itself, simply holding a H-4 visa, H-4 status does not authorize work authorization.
If you have a history of a long administrative processing for your past J-1 visa stamp renewal process, will it affect the application of your EB-1, EB-2 in the future?
So it should not. So what we're talking about here is two different issues. You're talking about a consulate issue. So the consulate officer, for whatever reason, has had issues with the adjudication and issuance of your J-1 visa stamp at the consulate. That might, for whatever reason, sounds like a 221G administrative processing issue. And that's a very broad area, so I can't comment upon what it would be. Will that indicate, or will that affect the application of an EB-1 or EB-2? No, it should not, because at the end of the day, an EB-1 application, EB-1A or EB-2 NIW, should be adjudicated on its merits. If the issuance of the green card, if you've got some problem in your personal past, then that may be impacted. But no, the EB-1A and EB-2 NIW should be adjudicated based upon your professional credentials, contributions, accomplishments, etc.
Next question is, can one travel outside the country while applying for the J-1 waiver?
I'm going to say, I have to, again, tread very carefully because I cannot give specific advice on a question like that. If you have applied for a J-1 waiver and then travel outside the US, could a CBP officer feel that you were, in conflict? I would caution someone about doing that.
This next person was in the US for 4 years on J-1, then left to another country, which wasn't this person's home country, and then came back on J-1 again. The visa says 212E not required. Does this person still need a waiver?
Well, again, so that's a specific question that I can't answer because, when I can't get into specifics. What I will say broadly is that if you are subject to the 2-year home residence requirement, that is, you have to, if you are going to fulfill that requirement, i.e. not get a waiver, the home requirement is your home country. So it's not the country next door. So in the EU, for example, we have freedom of movement. So let's say, for example, you're a French national and you're subject to the 2-year home residence requirement. You go to the US and then you leave the US and you go back to Germany for 2 years. Have you fulfilled the 2-year home residence requirement? No, because you didn't spend 2 years in France. So at the end of the day, fulfilling the requirement is your place of citizenship or last permanent residence. So I can't comment on a specific question, but broadly speaking, you would have to fulfill it based upon one of the countries that was on your DS 2019.
Okay, so for Indian and Chinese nationals, if they have already approved I-140, but before they get I-485, can they still be on J1?
Again, I mean, I appreciate people have these sort of individual questions. It's quite difficult. I cannot make, give answers on specifics. Again, broadly speaking, the I-140, the application of an I-140 is an immigrant petition. It would evidence immigrant intent. And would that cause an issue to have a J1 visa issued at a consulate? I would imagine that would be in play. And would a university issue a DS 2019 if they were aware of an individual having had already filed an I-140? That would be probably their prerogative. So I can't really say more than that.
Can you come in and out of the country as your green card is being processed?
Well, that's gonna depend upon what your status is. As I indicated in the webinar, for example, if you hold H-1B status and you have a H-1B visa in your passport, it's a dual intent visa. You can continue to work and travel as a H-1B non-immigrant while the green card process is pending.
For someone who already holds a green card, can you lose it after not being in the US for 1 year?
Yeah, so that's a very case-by-case basis. Abandonment of permanent residence would be based upon the factors of a specific person's case. So I can't and don't really want to give I can't give a specific answer in terms of, 1 year versus, 364 days versus 366 days. So it's factors would be looked at. Did you abandon? But at the end of the day, as a green card holder, the United States should be your place of permanent residence.
And the next one is a two-part question. So someone who has already EB-1B I-140 approved, 1, can they change the employer? 2, can they leave the country and come back when PD becomes current?
Well, I mean, keep in mind that an employer-sponsored application is an offer of permanent employment. An EB-1B, an employer could file an EB-1B on your behalf without you ever having set foot in the United States, and that you would only then be able to come to the US on a green card when it becomes current. So, I don't want to get into specifics over changing employer. Those are sort of legal questions.
Yeah, so I see a couple of questions that basically ask how many citations do you need, how many first author papers, that kind of stuff. So what can you comment on that in general?
Well, I mean, what as I tried to sort of communicate in the webinar, it's a case-by-case basis. There's not a specific number. How many first author paper citations and reviewed required to file EB-1. So let's say, for example, Cell, Nature, Science, New England Journal of Medicine. You publish 4 papers, and those are your first named author on those 4 papers. That carries, in all likelihood, way more significance than someone who has double or treble the amount of papers in lowly ranked journals. So I think it's important to sort of look at it, take stock, and what is most relevant? How much does it move the needle? And that's why I find it important to sort of look at your case. This is not a one size fits all, answer. So that's why I tend to look at people's, background, case, strengths, individually. It may be, for example, you may have lesser papers, but you may be, K-99 grant from the NIH or something. That probably means more than, so it's not just based upon, such it's like, oh, I've got X number of papers, therefore I've got Y number of say. Let's look at the totality of the strength of your case.
So what I gathered is you're basically suggesting people to basically contact a lawyer and go over your application with a lawyer or your CV, I guess.
That's what I suggest. I mean, I look at people's CVs all the time, and it may be, for example, let's say someone had a lesser number of citations, but somewhere over here they had a much more enhanced background and CV than the person with slightly more citations. Who has the stronger case? Because if you're a PI on sort of government grants, or if you're, things like that, you may have a stronger case than someone who maybe has just published slightly more extensively, who may have been cited more, and okay, they're box checking a little bit. So I think some of those factors should be definitely properly reviewed, evaluated, and feedback given.
Don't be afraid, contact a lawyer, guys. So I guess next couple of questions are about timelines. So for example, someone who's on G1 and needs to go on to academic H1B, what's the timeline?
That's going to depend upon how quickly the sponsoring organization or institution are able to take to file the H1B. Once the H1B is filed, they could file for premium processing, so you could get an adjudication in 2 weeks. But different organizations, companies, institutions, sort of move at different speeds in terms of how quickly they get to file the case.
I have a 2-year rule on my G1, but already applied for a waiver which is under processing. Can I start filing for the green card or wait till the waiver is approved?
Again, you can file for a green card at any time. That it may have ramifications on your status. It may have ramifications on your ability to travel, etc. But as I said earlier, the filing of the green card is, do I qualify for a green card? It's a fancy way of asking a very simple question. So the answer to that is, yes. Now, if you're eligible to file for your adjustment of status, you would have to wait for your waiver to be approved. But the filing of the immigrant petition can be done at any time.
For someone who's currently on G1 and is going to their home country to renew their visa, will applying for the green card lottery affect the renewal?
It shouldn't. But anytime, again, I will speak more broadly, anytime you present yourself to a consulate officer for issuance of a visa, your entire US immigration and visa history is in play.
Can an F1 student, does F1 student need to exhaust their OPT to be able to apply for EB visa?
No, you can apply for an employment base. You can apply for an immigrant petition for alien worker, EB1A national, EB1A extraordinary ability, or EB2 NIW at any time. Does it have ramifications for ability to travel? Does it have other ramifications? Potentially, yes, but you can apply for it at any point.
For someone who's on OPT currently, can they apply for CAP exempt H1B and I-140 at the same time? Will that influence international travel?
Filing for an I-140 can potentially impact international travel, yes, because it is evidencing what we call immigrant intent.
Repetitive questions. Is there a premium processing option for a green card?
Yep, there's premium processing for both the EB1A extraordinary ability and the EB2 NIW. It's $2,500. The EB1A, I think the adjudication timeline is 15 business days, and for the NIW, it's 45 calendar days, I believe. There is not a premium processing option for the final step in the green card, i.e. the adjustment of status, because that involves administrative processing and background checks.
If a person already has I-140 approved with EB2, can they apply for EB1 category? And once a green card is issued, after showing intent to work in the applied field, is there a time limit before willing to switch careers?
Look, the bottom line is that you should be showing the intent to continue working in your same or allied field. There's not necessarily a bright line in the sand, and that would be the type of, I think, situation or circumstance whereby I would need to sort of review and discuss with the person on a more specific basis.
If someone has H-1B working for a nonprofit and wishes to switch to industry for a profit company, do they still fall in the water if they have never been part of one?
Yes, you cannot take a cap exempt H-1B and pour magic sauce on top of it and make it a cap subject H-1B. You'll probably need to enter the lottery. There are limited ways and means that, for example, a person may be able to hold a concurrent H-1B, but merely holding a cap exempt H-1B does not enable you to transition that to a cap subject H-1B.
Is it safe to move to industry from academia with only a approved I-140?
I mean, it's quite an open-ended question, so I'll be honest with you. I wouldn't really be able to answer or comment on that.
Is there any hope for Indian EB-1A applicants? How's that timeline look like right now?
Well, yes, of course, there's hope. People will continue to pursue these options and get their green cards. Unfortunately, for Indian nationals, are there more roadblocks than for others? Yes, the answer to that is yes. There's no question about that. And so, however, therefore, I think taking steps to maybe start the process earlier for EB2, give yourself a safety blanket. I mean, the timeline for EB1As is now backlogged by at least a couple of years. So how that's going to play out over this fiscal year, I don't know. We'll keep an eye on what the State Department's visa bulletins will be. But yes, I mean, the system is the system. It's an imperfect system. We have heavy retrogression for Indian nationals under EB2. We have somewhat significant retrogression now under EB1, and unfortunately, it is a negative impact, but it's going to be hard to know what the timeline is looking like moving forward.
I'm gonna paraphrase this last two-part question. I think they refer to EB1 and IW. How much the EB2 application costs through a lawyer, and second part is how much would it take to get the green card on average?
Well, I mean, different lawyers charge different amounts. I actually just recently worked with the MPA and I gave them some guidance. I think there's a number of factors that you should look at when choosing an attorney. Cost, maybe one of them. There's a number of other factors. I don't want to get into what our fees are in this setting. I'm not here to do that. So different firms are going to have different fee structures. Different firms are potentially going to provide you with slightly different services. Do you want a purely transactional service, or do you want someone who's maybe going to work with you or talk to you about collateral issues and things like that? So I think there's a number of different factors in terms of, how to choose an attorney. How long does it take to get the green card on average? It's difficult to say based upon which EB category you pursue, where you're from. And as I mentioned earlier, unfortunately, there are some discrepancies and inconsistencies in adjudications.
Maybe you can clarify about the timeline just so people understand. I believe you first have to get the NIW approved, but then there's a sort of a wait line for the actual green card. It's currently about 10 months behind for non-Indian and Chinese, correct?
Well, right, it's about 10 months behind, but we're going to see sort of forward movement throughout this fiscal year. So what that looks like, we just don't know. And it moves back and forth. There was a period of time whereby the adjudication of the I-485s that were concurrent with the I-140s were remarkably quickly. I've also seen periods of time where I'm like, what are they doing? Are they even adjudicating cases? Because these cases are just sitting there. So yes, right now, as my slides indicated, you cannot file to adjust your status until they reach your priority date. If it moves month to month, that'll be about 10 months from now, but we just have to keep an eye on the visa bulletin to see. So it's a little difficult, I think, to quantify what the timelines are going to look like moving forward.
So people who get the NIW approved really need to think about having or just making sure they are in status before they can even apply for a green card, correct?
Correct. The filing and or approval of an NIW application does not in and of itself grant you status. It indicates that you qualify for a green card. In order to remain in the United States, you have to continue to maintain a valid non-immigrant status.
Okay, last question. We have 2 more minutes. If both spouses have I-140 approved with different priority dates with their respective employer, if one date becomes current and application is picked, will the spouse be tagged to the primary applicant?
Yes. The spouse can, both spouses can jump on the same bus.
So I think that was the last question that I see in the chat. Everyone, I really hope you guys enjoyed the session. I really would like to thank Brendan Delaney for joining us today. As always, every year we do this, and he always graciously agrees to enlighten us about the complicated process of green cards. Please make sure if you do want to consult with a lawyer, we're gonna post, then you can probably Google just Brendan Delaney, immigration lawyer, or we're gonna post this video on a YouTube channel, so you can always get a consultation probably, right?
Yeah, I mean, we certainly are here for people to reach out to. As I said, we provide and we provide sort of free consultations in terms to give people the type of initial feedback that they may want or need on a potential case, to take a look at their resume. So I'll be more than happy to talk to people in that regard.
Don't be afraid, guys. Lawyers are not scary, I promise. That's what I hear the most from people, that they're afraid of contacting a lawyer. Yeah, other than that, thank you so much, and we're gonna finish the session. Thank you, Brendan, and I hope everyone has a good evening.
Thanks again for having me.
Yeah. Bye, everyone.